Good evening, everybody. This is our first event of this academic year. The topic is the wholly incomprehensible subject of designs. I think you can protect the shape of an article by 8 different IP rights. And the Patent Office are thinking maybe we should bring it down to 7, or possibly 6. But patent lawyers will probably find some more new ones. I'm going to keep out of this now. My job here is to say welcome, and I've done it. Oh, one other thing, phones off.
Robin, thank you very much. And good evening, everybody in the room and those watching online from elsewhere. My task is to do some brief introductions and some house rules to start with. The full biographies of our speakers are available online, but briefly, Jeff Lloyd, to my far right, has been Deputy Director for Trademarks and Design Policy at the UKIPO since 2021. He is responsible for the current consultation on UK designs, which closes tomorrow. For those of you who are not ready, I am told that extensions are possible, but they would prefer you to ask for one rather than just to assume that you've been given one. Jane Cornwell is a senior lecturer at intellectual property law at the University of Edinburgh and a former solicitor in private practice. It is very important that we not forget Scotland in this discussion, and indeed Northern Ireland. Nina O'Sullivan is a partner and head knowledge lawyer at Mishcon de Reya's Innovation Department and a visiting teaching fellow on the Copyright and Design module of the Certificate of IP at Queen Mary, University of London. I'm glad I got through all of that. Some very brief house rules. What we've decided to do is that each of our speakers will give a short presentation of between 12 to 15 minutes. We will then have a brief discussion amongst ourselves, and then we'll open it up to questions from the floor after each speaker for about 10 minutes. So we'd ask you not to interrupt the speakers while they're at the lectern, but we are very keen for questions, not statements, from the floor, very keen for questions during the allocated time. So my aim is to try and maximise the debate and the discussion in the room. For those of you not in the room, I'm afraid there's no facility for you to ask questions, but hopefully the debate will nevertheless be lively and you'll enjoy watching it and listening to it. And a reminder, and I think this is the last of the House rules, that any views expressed from the panel, and that includes me, are not necessarily the views of the organisations or entities with which the speakers may be associated. With that, and no further ado, Jeff, do you want to take the podium?
So I'm just going to talk through where we've got to with the designs consultation. As David said, it closes tomorrow. It's been running for 12 weeks, so it started on the 4th of September. And I just want to start with setting the scene. What I'm going to set out is some of the things we proposed, but also some of the emerging themes. And I have to, because I'm a civil servant, give you a big caveat for that we haven't analysed responses that we've had to the consultation yet, but these are themes that are emerging from the programme of engagement we've done during the 12-week period. So I will start with just setting a bit of the scene. So this is intended to be a major and fundamental review of the UK design system. It hasn't been looked at for a number of years. We think it is ripe for reform. We are getting a number of different messages about issues with the system, which I'll come on to. We began this process with a call for views in 2022, and we had a linked survey to that was a simplified version of the call for views, so that small businesses, loan designers could access that. We conducted a further survey earlier this year in advance of the consultation on principles and what people value of the system, like cost, speed, etc., etc. And that informed the consultation then. What we've heard is that simplicity, validity, cost and speed are all very important, and we need to balance that with any interventions we plan post-consultation. We're also hearing, and have heard for a number of years, that the current system is complex and difficult to navigate. So Robin had alluded to that in his introductory remarks. So that is also something we want to look at. So we set ourselves some key objectives, which are what the proposals speak to. So firstly, we want to improve the validity of registered designs. We are seeing increasing numbers of anti-competitive filings, what we are calling anti-competitive filings, essentially the filing of designs that aren't original or are just frankly blatantly copies of other designs. We are seeing that increasingly. We think it's driven partly by increased use of online marketplaces, and people are using those copies for takedown notices. But whatever the driver, it's a problem because we stopped searching on originality in 2006 when we aligned with EU law on that. And clearly there are people misusing the system as a result. We want to simplify the regime, as I mentioned earlier. We want to make it more accessible and easier to understand. And we want to also address issues on the disclosure of unregistered designs. So when we left the EU, we lost the reciprocal recognition of disclosure, creating unregistered design rights. So we want to try and address that issue, and there's a number of options in the consultation. We also want to update the system so that it adequately is adapted to current technology and ideally for future technology. So particularly how we deal with animated designs, graphical user interfaces, and we've got some proposals on how we deal with computer-generated designs as well, in light of the increased use of generative AI across society. And then finally, we've got 2 calls for evidence sections in the consultation on our enforcement framework. So on improving the validity of designs, we've ruled out a full search, partly because it wouldn't necessarily be comprehensive, and also because it would almost inevitably, if we did it for all applications, increase cost and slow down the system, which is not what people are telling us they want. So we are looking at 2 options, a 2-stage system, which is based on the Australian system, whereby a design on application becomes pre-registered, and then it can't be enforced until it has been searched. So if you wanted to enforce the design, you'd have to ask for a search and pay a fee for it. And we're also consulting on giving the registrar further powers to search and to object on grounds of novelty. And we've got another set of options in the consultation on bad faith and opposition and observation periods, which are so we've got kind of a suite of options on improving validity, and we could take forward some or all or none of them, depending on what people tell us. So that's where we are. That's what we've proposed on that. So what are people telling us so far? Unsurprisingly, people value the low cost and the rapid, the high speed of the current system, how quickly you can get a design registered. So any change to search and exam would need to be proportionate and would need to balance that. Bad faith, if we introduce that, that's a brand new thing for designs. There's no case law, so it would likely have to, the parameters of what constituted bad faith in designs might have to be determined by litigation. And there's also a question of how bad faith would interact with new search and exam processes. And frankly, if we introduced a power to object on originality, would we need a bad faith provision is a question we've been asked. So that's something else we are thinking about. And observation and opposition periods would need to be linked to powers for the registrar to object to design to object to designs. And then on simplification, so we are looking at firstly deferment. So deferment is a matter of practice and not law at the moment. So you currently have a 12-month period as a result of practice. But we are looking at making it a matter of law. We've proposed in the consultation an 18-month period, which would align with patents and is, we thought, a reasonable compromise between the current 12 months and the 30 months in the EU IPO. But we have heard messages from some that alignment with the EU IPO might make sense. We've got a raft of miscellaneous changes as well in the that are essentially tidying up and updating the regime. Things like we can still accept specimens of designs, which is frankly is archaic, and nobody really knows what we'd do if we had one. So that's the kind of thing we want to kind of tidy up. And then we've got proposals on simplifying the unregistered regime there, which including the overlap with copyright, and they're on the slide there. So essentially, this is the complexity that we're trying to address. I'm not going to say much about this, but you're all probably familiar with it. But this is essentially the different rights and the different terms of protection and the different qualifications and what the right protects. And that's an illustration of the complexity we're trying to address. So what are we hearing from people as we're talking to them? As I said, on deferment, there's some feeling that we might want to align with the EU IPO at 30 months instead of the 18 months. If people feel that is desirable, we'd welcome people feeding in their views on that. There's clearly people value the different protections offered by the current unregistered regime. So the fact that different rights protect different things, and you can rely on different rights depending on what you want to claim. So any simplification, we'd probably want to preserve the range of protection that we've got now. It's been suggested that we could potentially focus on harmonising qualification requirements and or term of protection. And then in terms of copyright, the main overlap is on works of artistic craftsmanship, which isn't really clearly defined in law. So that's another point of confusion for designers, businesses and users of the system. We are looking at, we are looking at whether a clearer line can be drawn, or we are asking whether a clearer line needs to be drawn. There's some feeling we've had in speaking to stakeholders that the copyright issue needs wider consideration on its own potentially, but we'll take that away if that's what people tell us. And then disclosure. As I said, we've lost mutual recognition of disclosure of unregistered designs, so we're proposing 4 different options. So simultaneous disclosure, unilaterally recognising that. A grace period whereby a right could be disclosed outside the UK, but there would be a period in which it could then be disclosed in the UK to create a UK unregistered right. And then 2 options on creation of an unregistered right, either anywhere in the EU or anywhere in the world if it comes to the attention of relevant trade circles in the UK. And in terms of emerging themes, we've certainly heard that EU law on disclosure has not been fully tested. So there is a question over whether there is a EU disclosure law actually territorially limits to the EU or not. We obviously want to get the best options for UK designers and businesses, but beyond that, there isn't a clear consensus around any of these 4 options at this point. And then updating the system for technological developments. So we've got 4 options on graphical user interfaces, ranging from guidance to amending legislation and adding descriptions as well. So we're hearing very strongly that people would like clarity on graphical user interfaces and animated designs. Currently, sequences of drawings are required to protect an animated design, which isn't really ideal. So we are looking at that. And then on computer-generated designs, at the moment, there is provision in law to protect computer-generated designs without a human author, and we think that captures designs that are essentially created by generative AI. So we are considering removing that protection. We think that keeping that protection could put sort of human creativity, could limit human creativity in designs. So computer-assisted designs would still qualify. The one theme we have heard very strongly on this is that we would probably need to legally define what without a human author means very clearly, because obviously there are ranges of ways you can use an AI to create a design or to help you create a design. And we have a supplementary option there on gathering data on the use of AI. So yes, as I said, there's a clear need for clarity around GUIs. We've had some discussion with stakeholders around how you would claim parts of a design in an animated file. And then in computer-generated designs, as I've said, the need for clarity is coming through very clear. We don't ideally want this repeatedly litigated, and we're also very conscious of the ongoing debate on copyright and AI and computer-generated works there, and we probably ideally want to be consistent with that. And then finally, on the enforcement framework, we've got two elements here. So firstly, criminal sanctions for designs infringement. Currently, there are criminal sanctions for registered designs where there's intentional copying. Anecdotally, those sanctions are not well used. There have been very few, frankly, single figures, I think, prosecutions using those provisions. But there are calls for extending criminal sanctions to unregistered designs, and opinion has, at the call for view stage, was mixed. There is, as I'm sure you'll appreciate, quite a high bar for introducing new criminal offences into the system. You need strong evidence. So we've asked for further evidence on that in this consultation. And then the last call for evidence is on adding design infringement to the IPEC small claims track. It already is all pretty much most other IP cases, so it does seem to make sense. It would deliver better access to justice for small businesses and loan designers. So, but we are calling for evidence on that. There we go. And on emerging themes, the opinions on criminal sanctions remain divided. We need to evaluate the evidence we get in a fair and qualitative and not just a quantitative way. And then on adding registered design infringement, I think we've had some low-level concerns raised, but I think generally it seems to be regarded as a fairly sensible move. It was described in one event as a no-brainer, so hopefully it is. So that's where we have got to. In terms of next steps, as I've said, it closes tomorrow. If you haven't got a response in, please do get it in now if you want to get it in. And obviously, and we will also extend time as needed. We'll review everything we get. And we expect to publish a government response in 2026 that will set out where we go next. So that's it from me.
Jeff, thank you very much. For those who joined us a little later, the process is we'll hear from each of our speakers for between 12 and 15 minutes. We'll then have a 5-minute chat amongst ourselves and then open it up to the floor for 10 minutes after each speaker. So please do get your questions ready so that everyone can join in that discussion. But we get a little go first, so we'll do that now. Jeff, the EU has just been through a 9-year design reform process that came to what I think are eminently sensible amendments that really reflect current practice, both there and here, largely. But there's nothing in the consultation about shouldn't we just adopt all those wholesale. Now, I'm conscious there may not be political will just to adopt EU law because it's EU law, but there might be political will to do it because they're all sensible suggestions. Is that a possibility?
It is a possibility, and if people tell us that that's what we should be doing in responses, then certainly yes, we could consider that. We wouldn't adopt it because it's EU law, but certainly the government recognises the EU is a huge market for UK businesses and UK designers, and we do keep an eye on what the EU is doing and what other jurisdictions are doing, and are happy to feed that into our thinking.
Okay. Another thing they did, just while we're on the point, is neutralised all the gendered language in the regulation, the directive. So that might be something that might be fun to do, or appropriate to do here as well. Works of artistic craftsmanship, for example, might have another term. Jane, Nina, do we need one of my concerns about this process is like a jumper. You pull a woolen thread and the whole thing unravels. All of this has to work together. Do we need something like the Hargraves review to make it work together?
I think something that I find striking is that there are certainly interdependencies between different sections in the consultation. So we are, for example, contemplating criminalising unregistered design infringement while also radically reforming unregistered designs. Nina will also be talking about possible changes to the rules for subsistence, coming into subsistence of UK SUD, but that's also possibly something that might be the pillar around which all unregistered designs are harmonised. So there does seem to be interconnections, and it does seem very important that these things are all pulled together. It also does seem to me that there are some very significant issues of principle raised, particularly in the question about or consolidating unregistered designs. Rather than,
and the overlap with copyright.
And the overlap with copyright. For example, in terms of finding a partially or wholly consolidated unregistered design right, if that is what is the option pursued, can we just cherry pick bits from each system, or do we need to think really more fundamentally about what should be protected in the contemporary environment and why? And that is definitely a more major job, I would suggest.
I think it's the challenge, isn't it, of looking at these issues through the lens of design law. Not purely alone, because there are aspects of copyright that have been brought into the consultation paper, but when Robin did his introduction, he was talking about the other rights that are available to protect designs. And so I think, David, something like a Hargreaves review would allow a more comprehensive evidence-based assessment of some of those interconnections. But it could also really bring in some of the thinking around, well, what is our post-Brexit position? Which bits of the EU regime do we like? What is the impact of AI? And I think that would be really good to draw that together. My only concern is that is a mammoth task. I'm not sure there's necessarily the political will for that. And the problem for designers is that these problems that they're facing them now.
Yes, but we might find a former judge or an academic who could
in this room.
who could pull all this together. Can I also briefly flip back to Robin's comment about copyright? Because on one reading of COFAMEL, that as long as you have the author's own intellectual creation, that's all you need, life of the author plus 70 years. On one reading of COFAMEL, we don't need design law at all. So how do we have this conversation about design law without also looking at that? And many of us hoped Water Row would give us some answers, but for all sorts of reasons it hasn't given us some of the answers we were after.
Yeah, I mean, I think Water Row says, doesn't it, that those EU cases like COFAMEL are relevant still, but you still have to then apply this multifactorial assessment, which just makes it so difficult for rights holders to work out whether copyright might protect something that is a work of applied art. The other thing that I would add that I think is quite interesting is that I'm not sure the position in the EU is that clear-cut at the moment either. We had in the last week or so a decision from a Dutch court that the Birkenstock was not protected by copyright, whereas a German court has said that it is. We've got the decision of the CJU coming out next week, I think, in the Mio and Conquetra case. So design law and copyright and the impact and the interplay between them is still a moving feast, I think, in the EU as well. And the way the consultation approaches this is to say, well, it should be left to judicial interpretation, and I can understand why that has been put on that basis, but I think this is calling out for some sort of legislative response, because there's the wider concern around, well, what do we do about the closed list, for example, and that goes beyond what's in this design consultation.
Your turn. Who's first? If I could get you to give us your name and your affiliation.
Very easy one. Alina Trapova, UCL. How many responses, I appreciate that it closes tomorrow, the consultation, but how many responses have you received so far, roughly, since you have...
36.
Okay, thank you.
That's pretty precise. And how many extensions have you given, Jeff? 3 or 4, okay.
We're not expecting 11,500.
We're not.
You've got for the copyright one, no.
No, I mean, my benchmark for this is our call for views, we had 58 responses. I'd like to get somewhere around that or above, really. You know, we've certainly done an extensive program of engagement to try and reach as wide audiences as possible. So I would hope that we see a flurry tomorrow.
And I know there's a number of organisations that are putting together responses. Are you also interested in responses from individuals who have a view about just one part of it? You
Absolutely.
don't, and so an email saying, "I just want to respond on this bit. Here are my views." That's appropriate and acceptable.
Absolutely. The mailbox address was on the slides, so yeah, it's designsconsultation@IBIL.gov.uk. Happy to receive just emails. And the consultation is designed that people only need to respond to sections that interest them if that's what they prefer. And we also have video explainers in there for small businesses who might not be as familiar with all the background.
I hadn't realised I could send a video. I might do that.
Well, there's a video in there. There are video explainers in there. Yeah.
Next question, please.
Robert Guthrie, Osborne Clark. There's quite a small number of responses compared to the copyright consultation. One of my questions that sort of raises to me is how much is sort of industry sort of crying out for changes to design law? Is this sort of IP lawyers worried about intellectual coherence, or are these things impacting particular industries? Are there particular industries that are very concerned about the potential changes, or really, pushing for changes, or is this sort of more IP lawyers talking about it?
Jeff?
So I think it's a mix. There are specific industries that have specific issues with the system. The post-Brexit disclosure issue is a big issue for the fashion industry because you can't, show your wares in the Milan fashion show and have UK design protection, and that's a big issue for them, and that's why we want to try and address it. We are hearing, particularly from smaller businesses and smaller business organisations, that complexity is an issue. Dealing with navigating the different rights is an issue. Is an issue for people. But equally there is the legal community is involved in the discussions as well.
I mean, complexity is not a bad thing, of course.
No, we're hearing that as well.
and as lawyers, we often find the complexity and it provides flexibility and optionality, as it were, when it comes to enforcing design. So it's a real path that you have to tread, isn't it? Between simplifying but not losing aspects of protection.
Absolutely, yeah.
Question? If the next person could put their hand up so we know where you are, that would be useful.
Thank you. Belinda Isaac.
Hi, Belinda.
Hi. I'm very much interested in the suggestion that Jane made that it's time we had a full review of design law and how it interacts with the different provisions of copyright and so on. Because it seems to me we have a very piecemeal system, which is not satisfactory for a lot of reasons. And whilst the IPO is doing a valiant job, it does give the impression, without being disrespectful, of tinkering around the edges rather than dealing with some of the real issues that people face in practice. The point about designs, which makes it unusual, is that many designers and creators are individuals who, many of them, run small businesses, can't afford to register all of their different designs, and perhaps can't even identify which is the winner of their designs at the time that it's launched. And they don't always get the opportunity to take action if something is protected later on and something is copied later on. So I think I'd put a vote in for a full root and branch review, because I think that design is really worth protecting, where you've got really good design, and that we shouldn't be hidebound by what we've done in the past. Let's be radical and take the opportunity to provide protection that's really suitable for the future and designers of the future.
Okay, I'm not sure there was a question in there, Belinda, but, but we can...
The IPO has even considered a root and branch review in that radical way.
Any chance of a Hargreaves review, Jeff? Unlikely?
So, I think there's a couple of things. I think a Hargreaves-style review would lengthen the time period before we get any reforms, and as Nina, I think, said earlier, people are telling us the problems are happening now. And whilst we can't solve them overnight, particularly if we need to legislate, we want to progress this as quickly as possible. And on the tinkering around the edges point, we don't regard that as what we're doing. We think this is, as I said at the beginning of the presentation, we think this is a fundamental review, looking at all the problem aspects that have been brought to our attention about the design system, and we are happy to take it where the evidence shows it should go, in terms of policy interventions, which could be really fundamental.
Can I respond to that?
Very briefly.
I understand what you're saying if you look and if you address the issues of artistic craftsmanship, workmanship or crafts. I don't know how you're going to
artisanship, I'm going for.
Okay, artisanship. But I was at a presentation that you were involved in with the AIPPI, and the question came up whether this consultation is the right framework within which to be changing the Copyright Act in such a significant way. So if you decide that actually you've got to deal with the copyright aspects separately, then I think that may alter the balance of the approach that you take in designs.
Another question, or shall we go on with our speakers? Yes.
John Coldham, Gowling, WRG. Jeff, a lot of the stuff at the beginning of your consultation is about dealing with, may I put them as obviously invalid filings. They may not be bad faith, they may just be hopeless for one reason or another. Obviously, a lot of the questions are about what to put all designers through, potentially, depending on which option people go for. It could be a step that every designer who wanted to file a design has to go through. To what extent is an alternative on the table being considered, depending obviously on what happens as a response, to have a very, very efficient invalidity process? I appreciate you've got an invalidity process now, but anecdotally it takes sort of 4 to 6 months to go through. Is there a way of having a sort of really fast invalidity process, which, maybe it's only for the egregious cases, otherwise it gets bumped into a slower track or something like that. But is that an alternative that you are even considering? Apologies if it's in the consultation.
It's not, but it is an option that we could consider if that's what people tell us. I think it's something we could explore. I think we'd have to look at the practicalities of how we make it as quick as we can.
Do you want to come and set up? So you're ready
with sort of other pressures on our program side as well. But we'd have to look at it. But it's something we could consider. Yeah.
And that is a really good segue into Jane's talk, who is up next to talk about exactly that.
Well, thank you very much indeed. My remit is to talk about search, examination and bad faith as covered in Section A of the consultation. And I'm going to take the angle of focusing particularly on anti-competitive filings as a key driver behind these proposals. Anti-competitive filing being where an applicant files for an existing design which is not theirs, putting them in a position particularly to assert their registration against the true owner and other legitimate traders. And as Jeff has mentioned, a particular concern being the reliance on such filings in IP takedown in online marketplaces. Jeff has already outlined the proposal, so just to recap very briefly, focusing particularly on option 1. Here the proposal is to introduce a power to conduct a search and examination in some instances, but without the office being required to do so across the board. Option 2 is the proposal to move to an Australian-style two-stage system whereby the first stage is examination as now, but that only results in a partially registered design, and in order to be able to enforce stage 2 examination for novelty and individual character has to be completed. And then bad faith is also raised as a possible new objection for examination. Before I get into the detail, I want to start with a couple of case studies. Some of you will be very familiar with these, some may not. These are examples of recent invalidations, which they are not explicitly identified as such as anti-competitive filings. They may well be presumably, possibly the result of innocent misunderstanding, but they do, I think, serve to illuminate some of the issues. So, for example, this year we have seen not one, but 2 UK registered designs invalidated that were attempts to file designs for the Amazon Fire TV stick. Now, if we look at these, is there a clue that these are potentially problematic? Well, it's a very well-known product. There are also some very well-known trademarks on the handset, which might be unlikely to be licensed to particular individuals. In terms of the design proprietors themselves, one was a private individual, one was a company. Both were at the same, definitely residential-sounding address. Neither had been involved, as far as I can see, in an invalidation before. Now, in terms of the outcome, the eagle-eyed among you will see that there are some differences between the contested design and the prior art. The Fire TV logo has disappeared from the bottom of the handset, as has the little blue light in the top right-hand corner. Now, this was enough to make the contested design novel. However, the design was invalidated on the basis of individual character. It took 9 months to get one decision, 14 months to get the other. No costs were awarded because the invalidity applicant was unrepresented and didn't make a claim. A second case study example, very different looking prior art here. The prior art is from an Amazon listing for an existing third-party product. Here, obviously, the problem is that there's nothing really on the face of the contested design to flag up that it's a potentially problematic filing. It's a basic consumer product. There's no particular branding and so on, although obviously it's rather generic. Here, again, the case proceeded on the basis of individual character. And you might be asking yourself, why not novelty? The contested design had views that correspond to all of the thumbnails from the prior art, but the best evidence that the invalidity applicant seems to have been able to put forward was just the thumbnails, and they, of course, are not very clear. So I think implicitly, reading between the lines, the reason that novelty was not considered is presumably because the evidence wasn't clear enough. This took 21 months to invalidate, and there were £48 in costs awarded for the invalidity challenge fee. So in terms of key takeaways, if we think about anti-competitive filings from a design law perspective, they look like a pretty good business model. Filing fees are low, invalidity proceedings are slow, costs awards are low, and even on the official scale when parties are represented, they're not huge. And although IP takedown can be an unjustified threat, obviously the likelihood of proceedings being brought seems quite slim. So is there more that the UKIPO could do? My point has already been preempted by the question. For example, even without the reforms that we're talking about, is it possible to speed up proceedings? The appointed person has actually suggested in a decision that there should perhaps be an expedited procedure where there's been takedown based on the design in question. Turning to the proposals that are being looked at, I think these case studies do give us a few more key takeaways to think about. Firstly, how realistic, if we're thinking about the bad faith objection, how realistic is it to expect examiners to be able to raise bad faith of their own motion all of the time? It seems implicit that some degree of checking and searching is going to be necessary. And as soon as checking and searching is being done, this looks a lot like option 1. The two seem to morph together based on a suspicion and then further searching being carried out. Obviously, in terms of bad faith, there are the additional demands of demonstrating the bad faith mental element, if I can call it that, and also defining what that bad faith element would be. Bearing in mind that we have lived with decades to get to the sky kick test in registered trademark law, and the sky kick test does not necessarily transpose neatly across into the design law context. I do wonder whether, looking at this question in particular, it was a mistake to repeal Section 3.2 of the Registered Designs Act that required the applicant to be the person entitled and was a ground of an examination at the time. But there we are. I think also what these case studies show is that identifying the criteria through which suspicious filings would be sort of honed in upon for the purposes of selecting which applications to search and examine is going to be critical. Working from the applicant information is only going to take things so far, because not every anti-competitive filer will have had a prior invalidation, and of course many legitimate filers may have had a design invalidated for perfectly fair bona fide reasons. So the criteria will need to be developed, they will need to be refined, they will also need to be promulgated, and they will need to be stuck to in order to ensure that the selection of applications for examination doesn't look arbitrary. And it will also need to be known which filings have been examined or not. That will need to be something that third parties can know. Whether option 1 or option 2, obviously the choice of search tools will be key, but I think also, for my part, I think that the case studies demonstrate very much that if these options are not to risk being toothless, then examination must cover individual character as well as novelty. Because savvy applicants may tweak their designs just enough to get over the novelty threshold, or there may be limitations in the prior art evidence. So far my comments have focused on really sort of option 1 and bad faith, but to say a little more about the Australian two-stage system that underpins the option 2 proposal. So the basics are set out on the slide. The terminology in the consultation is different, so the aim is to refer to them, or at the moment anyway, as a design being partially registered or fully registered, rather than the Australian terminology of registered and certified. The key aim here is that essentially introducing this second stage seems implicitly something that's going to put off anti-competitive filers from filing in the first place, or at least if they do so, they will not make it past stage 2, and therefore they will not be able to enforce their designs. One of the innovations of the stage 2 examination is that it can be requested by a third party, and that is intended to provide a more cost-effective way of raising a concern than having to follow through on invalidation proceedings. Two key things about the Australian system. So firstly, no proceedings for infringement can be brought until stage 2 examination has been completed. And secondly, in terms of action short of starting proceedings, if there is a threat, for example, of any kind, and it's based on an uncertified design, then that's per se an actionable, unjustified threat. Two key things from this to think about from our perspective is that, firstly, we can see that action short of actually starting proceedings is still governed by threats rules. And also, as far as the prohibition on being able to bring proceedings, that will apply to everybody under a two-stage system. Good faith filers and bad faith filers, no one would be able to commence litigation and without completing stage 2. And to my mind, that raises the immediate question of whether legitimate filers will feel compelled to put as many designs that look to have commercial potential, first of commercial value, through stage 2 as a matter of course, in order to be in a position to be able to enforce their rights on discovery of an infringement. It is worth noting that in Australia, the rate of certification is low. Certification is the little light blue line right at the bottom of the graph. But the evidence in Australia is also that non-Australian registrants certify at twice the rate of Australian registrants. And it has been surmised that that is because non-Australian registrants are used to the idea or the norm of their rights being readily and immediately enforceable. I think that there are plenty of reasons to think that the rate of certification, or rather the rate at which stage 2 is engaged, could be considerably higher in the UK. And we have to think about what that might mean for the, system level implications in terms of just how many stage 2 examinations might have to be processed by the UKIPO. I think we all know that in many fields, design fields are crowded, there is a lot of prior art, there are nuanced and fine decisions to be made about individual character, and that seems that potentially something that could very much impact on cost and timescales for all users of the system. Importantly, research by IP Australia has indicated that there is actually confusion in Australia about the system there. And this is not just a terminological point, there is confusion about the nature of the 2 stages, but also that there is still assertion of uncertified designs without, the threats rules have not stopped that happening. And I think that that raises 2 further very important points to think about, which is firstly whether making a change of this magnitude would simply add to the existing confusion in industry among designers and so on that exists around the registered design system, but also whether realistically the Australian experience tells us that the 2-stage system stops problematic assertion of rights short of starting court proceedings. So very quickly, and I just add another quote here from a piece by IP Australia that points out that the assertion of uncertified designs is, according to their research, something that has been done quite deliberately in some cases. So just weighing things up on my last couple of slides, I wanted to try to evaluate the options across various questions. What do they do in terms of who bears the practical burden of dealing with invalid designs? Well, they do all of them improve the current position in the sense that the burden is no longer on concerned third parties to take on the role of policing the register. Who bears the costs? The consultation doesn't say a lot about cost implications. My assumption is that it could affect, all options could perhaps affect filing fees across the board. There will certainly be fees for requesting a stage 2 examination. And in terms of whether the measure is targeted or non-targeted and who it will affect, this is where I think we see the real very sharp difference between the options on the table. Option 1 and bad faith are intended to work as targeted interventions. They work on the basis that it's possible to hone in on, single out a problematic filing and deal with it before it makes it onto the register. Option 2 is quite the opposite. Option 2 introduces a blanket rule that affects all filers, legitimate or otherwise, and that everybody will have to go through. And I think that does raise a question that needs to be thought about as to whether option 2 is in principle or in terms of proportionality an approach that is appropriate. I also just wanted to evaluate, insofar as one can, at this very preliminary stage, what effectiveness might be of these options. In terms of them stopping anti-competitive filers starting court proceedings, that all options seem to be equal. That wouldn't be possible in any of these if they work properly. But the assertion of anti-competitive filings in court proceedings is not really the main concern. The main concern is about these rights being asserted in other fora, short of starting court proceedings. On that basis, option 1 and bad faith seem to be stronger because ultimately, if these filings are identified, no IP right will ever issue. Whereas for option 2, there will be partially registered designs. And that always, I would suggest, leaves the possibility of attempted misassertion of those partially registered design rights. Option 2 also has the difficulty in terms of dependencies. For it to work. In particular, online marketplaces would need to understand the new system. And my final question, and I will wrap up with this question, is to ask whether any of these present any real deterrent for anti-competitive filers and so on. And the reason that I've answered no to all of these questions is because on option 1 and in the instance of bad faith, The anti-competitive filer just files. They pay their slightly increased filing fee, and they take their chances. It's only really if the system works well and if it's seen to work well that perhaps behaviour might change. On option 2, the assumption is that an anti-competitive filer will never request stage 2 examination themselves, but they don't need to. They will still have a partially registered design. The evidence from Australia suggests that some might seek to still assert that, and that some targets of such assertion might not understand that it's not a fully enforceable right that's being asserted against them. And of course, if a third party requests stage 2 examination, then all that will happen is the design will be invalidated or effectively not fully granted in the same way that it is now. So that leaves me with the final open question, which is if anti-competitive filings are a major concern, does something else need to be done in order to have more by way of deterrent effect? But I will bring this to a conclusion, as I'm sure others have comments and thoughts. So, thank you.
Before we get into the questions, I'm going to ask for a poll from the floor. Based on what you've just heard, who will vote for option 1, which is a limited search, and who will vote for option 2, which is the Australian position? So option 1, hands up first. Option 2, the Australian system, anyone? And then those who think we should do nothing. And those who think we should do something else entirely. Okay, so there's some grounds for discussions here. Sir Robin, what should we do that's none of these things? Wait for the microphone if you don't mind.
Of course. First thing is simply straightforward, proper orders for costs when you get one of these misusers. And with great respect to the office, they have no idea what a proper order for costs is.
£48 isn't going to cut it.
It's not going to cut it, and it never has done. I mean, throughout my entire career, the office have never ordered some misbehaving character to pay full costs, indemnity costs. It almost seems it's not within the civil service character to realise there are bad guys out there, really bad guys. Secondly, these good faith applications, it applies just as much to bad faith applications to trademarks. It's not good enough to knock the thing out. Skykick provides no answer to clogging the register, because all that happens is they get back to where they were. You've got to say it's a curate's egg. It is in fact no good. And the person who did that has got to be dealt with accordingly. And I don't see why you shouldn't have a criminal offence of applying bad faith for a trademark and a patent and a registered design. And that's one to be tried not in the ordinary criminal courts, but in IPEC.
I broke my own rules. I broke my own rules by calling on you when we were supposed to have our discussion up here first. So, Jane, did you want to respond to anything that Sir Robin said?
Just on the comment about criminal offences, there is a criminal offence in Section 34 of the Registered Designs Act for making or causing a false entry on the register. And in the Woodhouse and architectural lighting case, which was, I think, dealt with some validity issues under the old system, but nonetheless there was a mention, but no more than a mention, of the idea that deliberately misstating the owner on the application form could give rise to that.
It's arguable. I mean, we put it in our submissions to the office, but it's arguable.
But there is an offence that someone could try.
But then who's going to prosecute it?
Nina, option 1, option 2, or something else?
I mean, I like the point about let's think about something less interventionist, I think, in terms of, and maybe that Jeff can expand on this in a moment, but we're told that the sample size of abusive registrations that were seen to have been filed were about 9%. It'd be interesting to know 9% of what. And
Is it about 7,000 a year?
The sample was 1,400, so it was over a period at the end of 2023.
Yeah, so it'd be interesting to know, well, what was it about those particular registrations that stuck out as saying, right, those are abusive ones, is it in particular sectors? I think it would be really useful to understand that, because we can then think about what's the proportionate response. So my vote is probably for something other than options 1 and 2, which would be the expedited invalidity that was picked up earlier.
One of the questions, Jeff, I had, and you may or may not know the answer, is whether the ones that were identified in the study as anti-competitive were represented or not, because there's been a discussion in trademark world for a long time about whether people who don't have some sort of regulation should be representing third parties before the office. So I'd be interested to know if the ones identified as anti-competitive were represented by a regulated entity or another, or had filed themselves.
I don't know the answer to that. I'm not sure whether we checked that, but we could certainly look at it. It's important to note the 9% is not original. They're not necessarily anti-competitive. So the 9% was, they were not original design. So it could be accidental infringement. So it could be purely just a mistake.
Right.
So, but that does say, we are also seeing other things in complaints we get and things like that that demonstrate the anti-competitive findings are a problem. But important to note that not necessarily the whole 9% were anti-competitive.
Jump in.
I think in the options assessment they said that there were a further 11% that was still being analysed. So if those were all for pre-existing designs, then we're talking about 20%. 20% of 80,000 a year is a lot.
Yeah.
One of the things that Jane picked up on was about fees as well, and it is very cheap to register a design at the moment. That's not discussed in the consultation, but it is, I hesitate to be suggesting that fees should go up, but is that something that's being looked at?
The fee for multiple design applications is incredibly cheap, and there is, I think it's a fair suggestion that could drive some of the anti-competitive behaviour, or at least make it more accessible. But equally, we've also heard over the last 12 weeks and before that people like that we're so cheap. So it's a tricky balance to strike, unfortunately. But I wouldn't disagree that the fees could be a potential driver. So we rule out.
Obviously, a lot of very good things have come out of Australia. I'm just not sure this is one of them. Australia has a tort of, well, it's a statutory tort of unfair competition, and I wonder if that might actually be something that helps us here, in that these anti-competitive filings are basically misleading conduct. There might be a wider question to be asked. Let's throw it open to the floor. Questions, please.
Thank you. I'm Matthew Ridley from Wade Tennant.
Hi, Matthew.
The question I have is the designs protection system the way to legislate against the way in which these bad faith filings are used? Because the problem here is not really that someone has obtained a registered design for a blatantly invalid version of the Amazon Fire TV stick, because when Amazon receives a letter accusing them of infringement, they probably have quite a good giggle in the office. And the problem here is online marketplaces and the way in which their takedown systems work. And my question is actually, should we be legislating in the way that those work? Because as a practitioner, I had one of these yesterday by complete coincidence, is what's happening is that people selling widgets on Amazon are selling them for 2 or 3 years. They suddenly see lots of other people are selling exactly the same thing, probably from the same factory, and they just register a design for £50, and then they use it to take down all of their competitors. And the problem then is that Amazon doesn't really respond to anyone saying, hang on, look, this is a blatantly bad faith. This is a clearly invalid registration. You can upload letters from lawyers. You can do everything. You can write to the other side. It's generally a Gmail or Hotmail address with some random sort of sequence of numbers before the @ and the name of the complainant doesn't seem to have anything to do with the registered design owner. And so I wonder, actually, is there something to be said for, instead of changing the design system, and I apologise to Jeff because I co-authored an article about introducing the Australian design system into the UK in the SEPA journal, but I actually wonder whether or not we should be legislating in the way that online marketplaces handle complaints, so that if, for example, there is no correspondence from the complainant, they must reinstate the listing. Just a simple thing like that could solve this problem.
Some would say that the takedown notice is an unjustified threat and that that's your remedy. But again, you've got to run off to court.
If it's a random email address, they respond and don't care.
Yes.
So the question is that better? Should we be legislating on that?
Other questions? Belinda.
I just wondered, we had a similar problem with people registering domain names using brands a long time ago. And the most effective means I've come across for dealing with that was the UDRP. It was not something that was managed by a court. It was much cheaper to make the complaint if you were the owner of a brand, and it provided a cost-effective, quick way of addressing it. And I wonder whether that's something the IPO has considered, not the IPO taking on the challenge of the bad faith, but actually letting the owners of the designs challenge the issue in some kind of forum, a bit like the UDRP.
Jeff.
Yeah, that's an interesting idea. I think the issues with the online platforms are that essentially they own their own processes, obviously, and those processes are arguably becoming pseudo-judicial and almost pseudo-registrar almost at the same time. We do have an ongoing dialogue with the online platforms. Going back to Matthew's point about legislating, that's probably a bit beyond my remit, but we do have an online dialogue with the online platforms, and we do try and raise these issues with them because it's a constant theme that runs through, across trademarks and designs, frankly. But that is an interesting idea, and I'm happy to take that back.
Other questions from the floor? Let me put the vote again now that you've heard that discussion. Option 1, limited search. Option 2, Australia. Oh, only one now. Option 3, do something else. All right, Jeff, you've seen that, and all that will go into the thinking. Nina, can I call on you to give your presentation? Thank you very much.
Good evening, everyone, again. I'm going to focus tonight on the continuing impact of Brexit, some 5 years, can you believe it, down the line, and the ongoing challenges that it presents for designers that want to rely on unregistered design protection in both the UK and the EU. So you'll remember that on Brexit, the already intricate designs framework was made even more complex. We now have 2 forms of unregistered design protection in the UK. We have UK unregistered design right, and we have supplementary unregistered design, SUD, and that was introduced on Brexit in order to replicate the EU unregistered design regime. And of course, this diagram is not as complex as it could be because there is another form of potential unregistered protection for designs, namely copyright. Now, Jeff has already, in his presentation, spoke about the fact that a major focus of the consultation is on potential simplification of this framework. and that's something we can perhaps pick up again in the discussion after my presentation. But for now, I'm going to focus on a specific post-Brexit issue, and that relates to the rules around what is required for SUD and EU unregistered design to arise. And this raises some difficult questions of statutory interpretation. It raises concerns of EU protectionism, and all of this results in a trap for unwary designers. So what's the issue? Well, many design companies, of course, they launch their designs on the internet, often through platforms such as Instagram, but a sizable number, particularly in certain sectors, and fashion is the obvious one, do so at international trade shows or in store. Now, based on one interpretation of the relevant law, a design which is first disclosed in the territory of the EU is protected by EU unregistered design, but cannot be protected by SUD in the UK. And a design which is first disclosed in the territory of the UK is protected by SUD, but not EU unregistered design. And so applying that interpretation, the consultation notes, it says a single disclosure cannot give rise to protection in both territories. So the dilemma then for design businesses that are operating across both the UK and the EU is, well, where do they first disclose their designs, and how do they best protect their design in the other territory? So, of course, they might decide to incur the costs of registering the design, at least in the second territory, provided they do so within the grace period. Or they might try to rely upon simultaneous disclosure to give protection in both. So that could be, for example, live streaming a trade show from one territory to the other. And we know that simultaneous disclosure happens in practice, but it is currently untested legally. Now, before we get to the potential solutions in section G of the consultation, I think we do need to test a bit more this view that a single disclosure can't lead to protection in both territories. And our starting point here is the EU's community design regulation. Now, this has recently been replaced, of course, by a new EU design regulation, but I don't want to overcomplicate too much, so we'll stick with this one for now. Now, when talking about novelty, Article 5 says that a design is new if no identical design has been made available to the public. Meanwhile, Article 7 tells us that a design is deemed made available to the public if it has been disclosed, except where that disclosure could not reasonably have become known in the normal course of business to the circles specialised in the sector concerned, operating within the community. So there is no territorial limitation there as to where the disclosure of the prior design must take place. To the extent there is a territorial limitation, it's focused on the recipients of the disclosure. And what this means is if you have a prior disclosure anywhere in the world, that may be novelty destroying in the EU unless it is an obscure one. Let's now look at Article 11. Article 11 deals with when unregistered design protection arises in the EU. And Article 11.1 contains a territorial limitation that we didn't see when we looked at Article 5 or 7. It says that a design shall be protected by an unregistered community design from the date on which the design was first made available to the public within the community. Now, it's not in terms saying that that first disclosure must take place in the EU, but it is saying that the term of protection of that unregistered design is calculated from that first disclosure in the EU. Article 11.2, meanwhile, that's similarly worded to Article 7.1. A design is deemed made available in the EU once it's been disclosed in such a way that those events could reasonably become known to trade circles in the EU. So we have competing interpretations. Does Article 11 import a territorial limitation, meaning that only where the first disclosure takes place in the territory of the EU will EU unregistered design protection arise? Let's call this the narrow view, or perhaps we call it the EU protectionist view. Or should a broader interpretation apply? So that says the first disclosure can physically take place anywhere, provided that it could reasonably have become known to the trade circles in the EU. And that's an approach based on awareness and impact of the disclosure rather than where it takes place physically. Now, those who support the narrow view, they were able to argue that any ambiguity on the face of Article 11 was removed when Article 110A5, catchy, was added to the Community Design Regulation. And that was as a result of new member states joining the EU in 2003. So you'll see that this provision says specifically, pursuant to Article 11, a design which has not been made public within the territory of the community shall not enjoy protection as an unregistered design. And so the narrow view is now the prevailing interpretation in the EU, at least for now. And of course, we have a key case here from the German Federal Supreme Court that I'm sure many of you will know, Gebäckpresse. And in that case, the German court decided that first disclosure of a design in China prevented the design qualifying for unregistered protection in the EU, and it also destroyed novelty in the design because it would have become known to the EU trade circles. And the German court said, look, any ambiguity has been removed as a result of Article 110A5. It would have no effect unless it was intended to clarify this as the correct interpretation of Article 11. Yes, it was merely an act of accession of new member states, but it applied across all member states, and it was categoric in what it said. In fact, so categoric that the court refused to make a reference to the CJU. Meanwhile, in 2019, the IPEC was also faced with this issue in the Beverly Hills teddy bear case. So the teddy bears in question had first been shown at a trade fair in Hong Kong and then subsequently at a toy fair in Germany. And His Honour Judge Hakon agreed with the German court's narrow interpretation in Gebäckpresse. He found it highly persuasive on a point of EU law. But he also noted there was no CJU authority, that the issue had divided commentators, and as it was not Act Clare, he did make a reference to the CJU. Unfortunately, as I'm sure many of you know, the case settled, which means we still have no CJU ruling on this issue. Now, the timeline now takes us post-Brexit and the UK's decision to create the supplementary unregistered design. Now, as this replicates the EU's unregistered design regime, this was a lift and shift of the Community Design Regulation. So that included Article 11, albeit with some tweaks. But this lift and shift was only partial. In particular, Article 110A was not included. Now, this makes sense, of course, given its provenance in an act of accession, but it also underscores the argument that post-Brexit, a territorially neutral interpretation of the rules on first disclosure should apply under UK law. That said, the government's Brexit guidance that came out at the time simply said first disclosure in the EU will not establish SUD, and 5 years later, we're yet to see a case before the UK courts as to what this actually means. Meanwhile, though, could the received wisdom be about to change in the EU? We now have a new EU design regulation. The wording of Article 11 has not changed, but Article 110A5, that provision that put the narrow interpretation beyond doubt, well, it's gone, but we don't know why. It was only announced in the very last version of the proposal. We don't know if it was a deliberate policy decision. I understand the view in Germany is that it makes no difference. The view there is that if indeed a policy change was intended, it should have been done more explicitly. But I think regardless of the why, the view that this issue is Act Clare appears to no longer hold good. And so if the issue were to come before a national EU court again, they should refer a question to the CJU. However, even though the way is now clear in the EU for a broader interpretation of the disclosure requirements, will that actually happen in practice? We all know about the EU Fortress Europe approach. If you look at the European Commission evaluation in 2020, before the design reforms, you'll see quite a lot of flavour of that in what that paper said about this particular issue. And it's important to note there is a wider context here as well, namely Article 3 of TRIPS. So denying protection for designs that are first disclosed outside of the EU, that may raise discrimination issues in relation to non-EU nationals. So that was quite a bit of context there to get us up to the consultation, but I think it's important context. This is section G of the consultation. What do we do about this issue? First of all, let's discount the options that are not on the table. So renegotiating Brexit, that is not going to happen. That's a shame, I accept. But it's a particular shame because reciprocity wording was in fact included in an initial draft of the relevant agreements, but was later removed. Allowing any disclosure abroad to give rise to SUD, that's also been ruled out, and that makes sense, of course, because obscure disclosures should not give rise to protection. Now, of the options put forward, as I understand it, and perhaps Jeff can clarify in the discussion, the UKIPO does not have a preferred view. So there are 4 options under consideration. The first is to do nothing. And I think, as we've just seen, there is a strong argument that under both current UK and EU law, there is no requirement that a design be first disclosed in a particular territory. But I recognise, of course, that until we have a definitive court decision on that point, doing nothing is simply going to maintain this symmetrical uncertainty that currently prevails, and that's simply of no use to designers. An alternative could be for the UK to unilaterally recognise simultaneous disclosure. So, for example, a disclosure at a trade fair outside the UK, if that's live streamed on the internet and available in the UK, that would give rise to SUD. That would bring legal certainty. But again, that's going to be thinking about questions of asymmetry if simultaneous disclosure is not recognised in other territories. Other challenges, of course, around simultaneous disclosure will be questions of interpretive nuance as to when a disclosure took place and whether it was truly simultaneous or not. Secondly, a grace period. So this is an interesting suggestion. How it would work is that after a design is first disclosed in one territory outside of the UK, there would then be a limited period of time for it to be disclosed or put on the market in the UK, and that period of time is to be discussed in the consultation. And at that point, once it is put on the market in the UK, that's the point that it would then attract SUD protection. Now, on its face, this brings more complexity, and that harks back to what we were talking about as to what designers want, and complexity is not something that they particularly want. But it does recognise that international trade shows often set the scene for product launches, and this would really make sure that that kind of factor was taken into account. It would also mitigate to some extent some of the concerns around asymmetry caused by the next 2 options, which I'll come on to in a moment. But, of course, it would put UK trade shows at a disadvantage. The last 2 options. So options 3 and 4, EU or worldwide disclosure. So these would explicitly recognise that disclosure in either the EU or anywhere in the world amounts to a disclosure in the UK, provided it's one that comes to the attention of the relevant trade circles in the UK. So essentially clarifying option 0 as it applies in the UK. Again, concerns about potential asymmetry. Again, concerns about damages to UK trade shows. So drawing that together, the overarching concerns that come out of the consultations do seem to focus on these concerns about asymmetry and reciprocity, as well as, when it comes to the grace period, the complexity around introducing new eligibility requirements. I guess one question that I would put out and I'd be interested to hear people's views on is well, how much of a concern is a lack of reciprocity in a post-Brexit environment? Is the better guiding principle that we need to be thinking about, well, what works best for UK designers to give them as much flexibility as possible as to where and how they disclose their designs without losing out on protection in the UK. Another thing before I just move off the consultation quickly is that the proposals in Section G are talking about SUD, but of course UK unregistered design right has its own complex qualification provisions. So as part of the proposals to simplify and potentially harmonise aspects of those regimes, qualification is earmarked as an obvious area where harmonisation would be helpful, and I think that makes sense. With all that said, I think it's worth stepping back and considering the extent to which the current situation creates an issue in practice for designers. And I think this goes back perhaps to Rob's point earlier about, is it designers that are asking about this? And I think here the evidence does seem to be largely anecdotal. We know that this is an issue in practice. We do know that most businesses prefer to disclose online. One example in the case law is the Rothy's case, which I think was one of yours, David, yes? Where online disclosures on a website website and via Instagram. Those were accepted as being simultaneous disclosures around the world, and that led to EU unregistered design arising.
To be fair, the parties agreed that.
They agreed it, did
yeah.
they? Okay, good. So that, but a sizable proportion of designers are not necessarily doing it online. They are launching at international trade shows, and they're being forced to implement these simultaneous disclosure arrangements or apply for registration. And that's if they think about the issue at all. And that's the point I come back to about this being a trap for the unwary. I think regardless of the scale of the problem, the very uncertainty of the current situation is in itself a reason to take action. And there have been overwhelming calls, as I understand it, on this particular part of the consultation for clarity. So hopefully the results of the consultation are going to ameliorate the position for designers. Thank you.
Fantastic. Nina, do you mind just flicking back to slide 14, which is the options?
Yes.
And I'll ask for a show of hands again. This is your chance to influence the consultation. Looking at those, well, there's option 0, so five options. Show of hands, option 0, do nothing. No takers for that. Option 1, simultaneous disclosure. A couple. Option 2, a grace period. That's interesting. Option 3, EU disclosure counts. Or option 4, worldwide disclosure counts, presumably with an exception for obscure designs. So there you go, Jeff. A mix of responses. Jane, do you think this is a problem in practice?
I think I'm maybe not the right person to answer in terms of the position in practice, being as I am an academic, but I suppose the one thing that comes to my mind, and I haven't sat it resolved in my head, is the idea if you have a grace period for the creation of SUD, you have a different grace period in relation to registered protection. Does that mean that there'll be parties will have to have 2 grace periods in mind if their plan is to rely on SUD for a period before filing? But I think in some ways this is more an issue for practice.
And the grace period could be, I mean, the length of that is still to be considered, isn't it? So it could just be 1 month, for example.
Yeah.
Jeff, did you want to respond either to anything Sean from the floor or anything Nina said?
No, I mean, I think, yeah, I mean, the views from the floor are interesting, because I did note down that nobody put their hand up for EU disclosure, I don't think, unless I'm very much mistaken, which is quite interesting. But global disclosure is, had a fair show of hands, so that's quite an interesting thing as well. Obviously, what we've lost is the EU reciprocity. But no, nothing else to respond to.
In just a moment. We'll do our little bit first, if that's all right. One of the things that slightly concerns me about the global disclosure is if there's also this push to have criminal sanctions, are we then in a position whereby a disclosure that's obscure-ish but not obscure in South America can lead to criminal sanctions here in the United Kingdom?
Yeah, I mean, I think the interplay between the different parts of the consultation, and that's one, is something we'd have to consider, when we're evaluating what we do.
Jolly good subject for the Crown Court in Snares.
Very tough.
Yeah, well, and that's the worry. We've not really talked about criminal sanctions. I was interested, Jeff, to hear you say that there's not been many. Again, there are some quite strong voices pushing for criminal sanctions for unregistered designs. There are other voices saying they should never have been implemented for registered designs and should be removed. How do any of us reconcile those two quite divergent views?
So I think that's why we've done this as a call for evidence. We want to, we aren't putting a favoured option on the table. We want to hear from, everyone who wants to respond on this question about, what is the issue and, what is the harm that is essentially being caused to designers through the lack of criminal sanctions, and we'd like to see evidence of that. And equally, the counter arguments, and I've heard quite a few of them over the last few weeks and before that. We'd also like to see evidence on that. I think we'll need to balance the evidence because, as you say, there are quite vocal voices calling for them.
Yes.
But we will need to evaluate, the evidence on its substance. So not just if we get a flurry of
people saying yes, please.
Similar responses saying yes, please. I think we'll have to evaluate them, as I said in the presentation, qualitatively as well.
I'm just going to take another little quick show of hands. The three options will be introduce criminal sanctions for unregistered designs, leave things as they are, or remove them for registered designs. So those are the three options. Introduce for unregistered, hands up. Leave everything as it is. Remove for registered designs. I suspect that's the opposite to what you're hearing loudly in your consultations, which is interesting. All right, throwing open to the floor. We have about 5 minutes to go, so let's jump in. Oh, sorry, there's someone down the back.
Oh, sorry. Jacqueline Reid, 11 South Square. I just had a question about whether you'd had any responses from criminal practitioners about the new application of criminal sanctions.
I'm not aware that we have.
So I just would have thought that would be one area where you might have some quite useful input.
Yeah, I'm
from
not
stakeholders.
aware of all of who has responded so far, but I'm not aware that we've had anything yet. But yeah,
It does sound as if there's only 6 of them who've done one. So
yes, but I thought that the criminal practitioners might have some views about how practical it would be. Much earlier in my practice, I actually did a criminal trial on trademarks. And they didn't get a conviction. I was acting for the defence. They didn't get a conviction. But that was under the 38 Act.
Right.
Shows how long it was.
Do we have stats on trademarks? How many criminal prosecutions there are for
I'm sure
trademarks?
It is quite difficult to get numbers around criminal cases.
Yes.
But I can check.
All right. Next question.
You might ask the Criminal Bar Association if they've got any evidence about that. The patent bar, the IP bar, they've got none.
Yeah. No,
We don't tend to do them.
You're called in.
Other questions? John again.
Sorry, monopolising question time. I just wondered whether it was fair to do a poll on the alternatives when they are, sometimes you could have more than one of them. You could allow, for example, simultaneous disclosure and then a grace period for other stuff. So I do, well, rather than, I don't want to question the method, but I do wonder whether a combination.
Did, yes.
All right, but a combination might be the answer here. And I, for one, have actually gone towards the grace period being the answer because it means that people have to have an interest in the UK, rather than just being a not quite obscure disclosure somewhere else with no intention of ever bringing that to the UK, which I hadn't expected at the beginning of the consultation, and I'm sorry that isn't a question.
All right, other questions? I'll ask one. What would we lose if we got rid of UK UDR altogether?
In terms of the data, I think it's worth bearing in mind. So Professor Estelle de Clay and colleagues did a very detailed study of all design claims initiated in all member states from the commencement of the harmonised regime through to the late 2017, so that includes the UK. And UK UDR claims were 50% of all design claims in the UK. And far outstrips registered design claims, and I think it's about more than 5 times as many claims as were based on community unregistered designs at the time. I think the natural inference from that is that UK UDR in practice is very useful, and there are fairly obvious reasons why it might be in terms of the subject matter that it can protect, the lower threshold for validity, and also the longer duration. I think the combination of those things are potentially very valuable. I think the last time that the IPO consulted on this, the feedback was that UK UDR is the ultimate fallback right when nothing else is available, but that doesn't necessarily mean that it's disposable.
So some might argue that the reason they get to court is because it's so complicated that it's very difficult for parties to settle.
Perhaps.
And quite often the case doesn't crystallise until either closing submissions or indeed in the judgment in some cases. Other questions from the floor? Lord Justice Arnold, can I encourage you to ask a question?
You raised the question as to whether to get rid of UK unregistered design, but the other possibility is abolish SUD.
Or amalgamate them.
Or amalgamate.
Bring them closer together at 7 years, for example.
Sure.
Other thoughts? All right. Our options are keep both separate as they are, so current position basically. Only keep the 3-year right, only keep the 10 to 15-year right, or amalgamate them at somewhere near 7. So those are the 4 options.
We have to order you something different.
I'm so glad I'm not a pollster, or indeed involved in survey evidence at all. All right, so do nothing, no takers for that. Only keep the 3-year right, no takers for that. Only keep the 10 to 15-year right, no takers for that. Amalgamate somewhere at 7, perhaps. Quite a few takers for that. And then what was your option, Belinda?
Do something else.
Do something else. All right, there we are. Can I thank our speakers for tonight? Extremely grateful to you all for the very interesting questions from the floor, for the feedback, for Jeff and the consultation, and to all of you watching from elsewhere. Thank you very much. And I think we're all, well, those in the room are invited to drinks back out in the reception area. Thank you.